name is Adrienne Fine. I'm one of the attorneys from the County Attorney's Office, and I'm here today to go over FOIA a bit. I know there may be some questions. I'll go through the presentation first so that if I know that it's being recorded for those who aren't able to attend, but then I will definitely take questions and happy to have a more informal dialogue about any questions you might have after the presentation. So I will start sharing here. Okay, is my present? I'm sharing my presentation, so let me know if you're not able to see it. Okay. All right. So as I stated, I'm here from the County Attorney's Office. The Freedom of Information Act is now being administered in the County Attorney's Office. So the first thing is, what is the Virginia Freedom of Information Act? And in sum, it is a state law that has two components of access. One is for documents and one is for access to meetings. And it is a right that's conferred on residents of the Commonwealth as well as representatives of the media, even if they're not a Virginia-based media entity. And so under FOIA, we have a responsibility to retain records for the required retention period, provide them when requested by a resident, and provide notice of public meetings. So as board members, we'll focus a bit on the meetings component of this, as I think that's where your involvement is going to be primarily. And so the first question is, well, what is a meeting? And under FOIA, it's anytime 3 or more members get together formally, informally, in person, electronically, or in any other combination, and public business is associated, discussed, or transacted. So if 3 or more members are getting together to have a play group for their children and no public business is discussed or transacted, that's not going to be a problem. But if 3 or more members get together and they're having any discussions about the topics that are the subject of your advisory group's work, that's going to be problematic. I believe it's not relevant to this group, but if a quorum is less than 3 people, then the quorum amount would be sufficient to become a meeting. So additionally, this applies to meetings, work sessions, subcommittees, anything that we call it, whether it is with or without minutes, whether a vote is taken, wherever the gathering is held. The key takeaway from the definition of a meeting is that it's very broad, and anytime that public business that is the topic of your group is being discussed or transacted, we should be treating it as a meeting and following the proper protocol. Things that are not a meeting, gathering of employees, gathering at, as I mentioned, functions where it's not for the purpose of transacting public business, you know, at a fundraiser, at a community event, things like that are not going to be meetings unless you end up discussing and transacting public business at them. And then public forums, you know, candidate appearances, debates, and things like that, where the basis is to inform the electorate, not discuss as a public body any public business. So those are things that are not meetings under FOIA. They're pretty narrow exceptions. And any time that public business is being transacted, it's generally going to be falling into the meeting definition. So if it is a meeting, FOIA requires notice. It has to be containing the date, time, and location, and posted at least 3 working days prior to a regular meeting. I believe the liaisons take the lead on those postings, but just making sure that you're aware that that's how much notice is generally needed prior to calling a meeting. And it has to be posted in a prominent public location at which notices are regularly posted in the staff liaison's office and on the county website. And there needs to be reasonable notice. If you have a special or emergency meeting, whenever you decide to call it, you need to let the public know as well. Emergency meetings do sometimes happen. I'm not sure that that is occurring all that often within the purview of your groups, but they are things that happen. And whenever an emergency or special meeting gets called, the public, if they can't get 3 working days, they need to get as much notice as the public body gets. So the next component that's required if it's a meeting is that openness. All public meetings, all public bodies, their meetings, including advisory groups, are open to the public. Work sessions, subcommittees, even if there's no vote cast or decisions made, unless it meets some of the limited exemptions under FOIA that allows for closed meetings, the meetings need to be open. 1 copy of the agenda packets and materials needs to be furnished to the public at the same time that the documents are sent to the advisory group. Voting has to be public, no secret or written ballots are allowed. And members of the media or members of the public can record meetings. You can, in your bylaws, put into place procedures that make that less disruptive, if it is disruptive to your in-person meetings, to have the recording occur, but we cannot stop, individuals from recording public meetings. And then generally, we will get into this certainly much further, much deeper, is that generally non-emergency electronic meetings of public bodies are not permitted. Currently, the state of emergency is still in place for the county, so electronic meetings are being permitted pursuant to that status currently. But when there's not an emergency order in place, there's no state of emergency, and electronic meetings are pretty narrowly allowed. So we talked about notice and openness. The next requirement for meetings under FOIA are minutes. They're required for any meetings, and they have to include the date, time, location, and the members present. If there is a motion for a closed meeting, that needs to be in the minutes, and then there needs to be a summary of the matters discussed, proposed, deliberated, or decided, and the votes taken. It's important to note that minutes, including drafts, are public records that are going to be released upon request. Okay, so as I mentioned, electronic participation in a non-emergency setting. The current law requires that members, if your group, your advisory group, has adopted an electronic participation policy, which hopefully they have, and if they haven't, they should adopt one prior to the state of emergency being rescinded, so that you can take advantage of these electronic participation allowances that are available in the general, in the Virginia Code. But if the group has an electronic participation policy in place, members can participate electronically due to disability or medical condition or a personal matter if there is a quorum physically assembled, the remote member's voice can be heard by everyone, the remote member has to notify the chair in advance, and the facts of the medical condition or personal matter need to be recorded in the minutes, and the participation has to be in accord with the electronic participation policy. Currently, the rule is that participation because of a personal matter that prevents attendance is limited to 2 meetings per calendar year or 25% of the meetings held per calendar year, whichever is greater. And if for some reason these items are not met, then the person can always listen in, but they cannot participate. They can't talk and they can't vote. So that's the electronic participation policy law as of today, when there's not an emergency order in place. Again, there is currently an emergency order in place that is allowing electronic meetings, and the General Assembly has gotten fairly far along with some new potential legislation, but they're not signed by the governor yet, and crazier things have happened than legislation getting changed or not signed. So we will wait to see what comes out of this General Assembly session, and certainly we'll be sending out updated guidance to the groups once we have that information. Emails and meeting. This is another area that a lot of the boards and groups are very interested in because it's the nature of trying to transact business in 2022. But the Virginia Supreme Court has held that meetings can constitute a meeting. Emails can constitute a meeting under FOIA if there's simultaneous email communication between 3 or more members. Unfortunately, they did not tell us what they mean by simultaneous. Is 2 minutes lag sufficient? Is 10 minutes lag too quick? Does it have to be literally simultaneous? They didn't give us any more guidance than that. So what we advise the groups to do is to avoid reply all. That frequently can institute or initiate a volley of emails back and forth and can frequently result in pretty quick communications depending on when it's sent. And additionally, if you notice that email communication is going quickly and really starting to get into the realm of discussion of transacting public business, we ask either staff liaisons or the board members themselves to help police yourselves and say, this is sounds like it's going to be a great discussion at our next meeting. Let's save it for the meeting. Let's put this on the docket for the meeting to kind of stop those sorts of communications that have risen to the level of becoming simultaneous or becoming a very spirited discussion that could be deemed a meeting. We also ask that you copy your staff liaison on all correspondence to ensure that the county has a record of the correspondence. That way, if we do get a FOIA request for all of your commission's emails, we are able to pull that through the county's IT department, DTS, so that I know generally communication is being had on your personal email accounts that the county doesn't have access to. So rather than having board members pull their own emails, if you will copy the staff liaison, then we can ensure that the county has a record of any email correspondence. Additionally, the retention period for an email may be longer than your tenure on the board and those sorts of things. So this makes it easiest for the county to ensure that the records are being retained and that we're able to provide them to members of the public when requested. Okay, so we are at the stopping point between meetings and records. So we can either see if anybody has questions about meetings now, or we can save that to the end if you want to ask any questions at the end. Does anybody have any questions about meetings, electronic meetings, emails, or anything like that? Okay, sounds good. Yes.
I do have one question.
Yes.
With regard to recommendations that the county might have made to the General Assembly about electronic meetings going forward, do you have any idea of what those might be?
So I think that there were a couple very promising ones that I would have given us the most flexibility that my understanding is that they were not successful in passing. For example, there was one that would have said, if you're an advisory group with no binding authority, you don't issue funds, you don't pass ordinances, you don't have any binding authority. One of the legislations said advisory groups, just let them meet electronically because of the nature of what they're doing. And I believe that one wasn't successful, but I believe some of the ones that were further along let the groups have a certain number of virtual meetings a year. I know that the county's position has been that we want to have as much flexibility for our constituents and for our volunteers as possible. But of course, it's a big state, and the county's willingness to be flexible with the commissions and how much virtual meetings occur is going to be bound by what the governor signs and what the General Assembly ends up officially adopting. But as far as I'm not aware of there being legislation that allows all groups to meet virtually whenever they want. I'm not aware of that being the case with the General Assembly laws. So as of right now, we're still in this operating under the state of emergency, and the board has indicated that they'll give at least 30 days notice, and they'll give sufficient guidance when, you know, if and when it gets to the point that there's going to be any changes. But as of right now, my understanding is that we are still in the status quo, and I don't have any additional updates about when that will be changing. Sounds good. All right, so I will go back to the public records. Let me know if you can't see my screen. So a public record is any record owned, prepared, or by or in the possession of a public body relating to the transaction of public business, regardless of the form. So whether it's email, text messages, handwritten notes, anything created in the transaction of business, in all public records are open to the public unless a specific exemption in the law allows the record to be withheld. So again, because my understanding is that this portion of FOIA is less frequently encountered by the boards and commissions and the advisory groups, I'm going to go a little less in depth on this, but for definitely ask questions if anything is going too quickly for you on this. But my understanding is that meetings is where we spend more of our time with FOIA with the advisory groups. So just so you know how the county responds to FOIA requests, we have 5 business days to give one of the 6 acceptable responses, either fully releasing the documents, fully withholding them, providing them in part or withholding in part, letting them know we need an extension, letting them know that we just don't have any records, or letting them know that there's going to be costs associated with production of the documents. Some of the types of things that are exempt are things like attorney-client privilege, account numbers, tax information, social services records. So the sort of things that you would envision being exempt, things like drafts that are not finalized, and you know, even communications that are labeled confidential, that's not necessarily going to be controlling in FOIA. Even if something is intended to be confidential, unless it's exempt specifically in FOIA, it's going to be public. So generally, whenever you're transacting business as an advisory group member, we just advise everybody to operate under the assumption that your communication is public and can be released. So my contact information is here. If you have any questions that you want to discuss confidentially or anything like that, I can be reached. I can also put my contact information in the chat if anybody has any emails or anything that they would want to send, but again, I'm happy to take questions, but otherwise, yeah, we're happy to provide any support needed on FOIA going forward. Does anybody have any questions?
I have a question.
Sure.
You said something about notes. So if we take notes during a commission meeting, those are open to the public records, or whose
Yes.
notes?
Your notes, yes.
And so how long do we have to keep our notes?
Honestly, I will be honest that that is controlled by the Library of Virginia retention schedule, and I would have to look it up. It's like a matrix. You put in what kind of information you have and can look up the retention schedule from there. There are you know, there is sort of if it's just a draft, you don't have to necessarily save drafts. I mean, there is some nuance there, but if that's something that you would like a little more guidance on, I'd be happy to look up that retention schedule and get back to you on that. Would that be helpful?
Well, if no one's ever asking for people's notes, I'm not gonna.
Well, I will say it's rare. It is a rare question. I think the more common one that we get is all records pertaining to and all communication and all, and so when someone uses all, then technically things like notes and things like that do fall into it. But quite frankly, most of the board's questions that we get, the board's FOIAs are more for minutes and official documents created during the official meetings and actions taken. Occasionally, there may be ones for emails, but ones for notes of board members are very rare. But I would say, the way to retain them likely would be to, scan them and you'd have an electronic copy. But that creates the same issue that we were discussing with not if you don't copy the liaisons that, if you serve your tenure and we thank you for your service and then you go on your merry way and the next day somebody asks for notes of the board members, the county doesn't have them. So I think if there are significant amounts of notes being taken, I've seen solutions where maybe there's like a folder where people can put stuff or things like that. But if that's a significant amount of documents being created, I think we should have a conversation on it offline and see how we can help. But if it's like notes here and there, I don't think it's anything where you would need to be really adopting whole new protocols for like 10 sheets of paper or anything like that.
So I have one question related to the first part of your presentation about like emails basically. So if we as a commission member, see this great article in the newspaper and we forward it to everybody,
Yes,
nobody responds.
right.
Is that fall under the FOIA?
So it does fall under FOIA in that it's a document created transacting public business because it's within the purview of the advisory group, but it's not a meeting. So if somebody asked for it under FOIA, we would give it out, but it's not a violation of the meeting, the prohibition on electronic meetings. Now, in that scenario, happily send it out, but I would recommend put everybody in BCC, and that way you can't get a reply all. It stops. It doesn't create an opportunity for it to get out of hand and have like a lively discussion. Because I mean, we've all been on email chains like that just, I'm on listservs where sometimes a topic really gets interest going and the speed that people are responding can be pretty quick. So I certainly understand, that's the world we live in, right? Technology and being able to just send out a quick response. So definitely continue to send the articles. I'd recommend BCC. Those emails are releasable, but as long as you're not doing the back and forth, it's not a violation of the meetings.
Okay, thank you.
Prohibition.
Thanks for the
You're welcome.
clarification.
Yes, happy to do so. All right. Does anybody else have a question? Okay, well, sounds
Wait,
good.
if nobody else does, then I got a question that's maybe slightly off topic.
Sure, let's do it.
So do these FOIA rules apply to condo associations as well as, advisory boards at the county level?
No, because well, I shouldn't say no. Typical lawyer response. These apply to government entities and public entities. So to the extent that an HOA is a private organization, that's not a subdivision of the government, the state, then FOIA would not apply to them because they're not a public entity. Now, I think the
I
only
guess I said FOIA, but I really meant like open meetings and some of the other things that we've been discussing today.
right. So so I'll finish the FOIA part and then I will give my lawyer additional caveats. So FOIA only applies, the open meetings requirement, all of that only applies, all of this only applies to localities and government agencies. Now, the one reason that I was feeling like I can't say that Virginia FOIA doesn't apply to any HOAs, because I guess there are some that are maybe like housing that's funded by the government and things like that. In those instances, there may be some implications there, but condo associations would probably in their own bylaws and things like that have rules that, and this is outside the purview of what I'm, here talking about, but they may have rules in their bylaws. And then, the state code does have some regulations of HOAs and condo associations and things like that that might be applicable, but they're not going to be under the Freedom of Information Act, and they're not the same requirements as the open meeting requirements that are the advisory groups are going to be bound by.
Unless they choose to adopt those rules themselves. But there's no state law that says you have to have these rules, but the condo themselves might adopt this policy.
There's no state law in FOIA, okay. in Freedom of Information Act. It's not expanded to include them, correct?
Okay, great. Thank you.
Yeah, you're welcome. So I can provide, Ms. Ned, I can provide you with the presentation as well to go with the recording if you think that would be helpful. But otherwise, definitely feel free to reach out if you have any questions in the future. And yeah, I think that's all I have. Oh, I think you're on mute, Ms. Ned.
Sorry about that. I hope the folks who joined us have found it useful, and we will make the recording available on all of the commission websites. So Housing Commission, Tenant-Landlord, and also CDCAC will also have a copy of the recording. So thank you very much for taking time out of your
Thank you.
Appreciate it.
You're welcome.
Thank you.
Have a good evening. Happy St. Patrick's Day.
Thank you, Adrian. Appreciate your time.